Jai Hind everyone. In this video, we are covering chapter 3 of Lakshmikant's polity, that is salient features of the constitution. So let's get started. The Indian constitution is unique in its contents and spirit. Though borrowed from almost every constitution of the world, the Constitution of India has several salient features that distinguish it from the constitutions of the other countries. So, what is saying? The constitution is like an amalgamation of all the good aspects that are provided in different constitutions of different countries, but the salient features distinguish it from constitutions of the other countries. It should be noted that at the outset that a number of original features of the Constitution as adopted in 1949, so a 1949 Act, have undergone a substantial change on account of several amendments, particularly. So in 1949, what happened? 26 November 1949, the Constitution was adopted. But although after that, there have been several changes to that, like 7th Amendment Act, 42nd, 44th, 73rd, 74th, 97th, 101st. And in that, among them, 42nd is important because it is also known as mini constitution. There were a large number of changes that have been made constitution under this act. So this 42nd Amendment Act is also known as mini constitution. However, in the Keshavananda Bharati's case, 1973, the Supreme Court ruled that constituent power of Parliament under Article 368 doesn't enable it to alter the basic structure of the Constitution. So, although there is a provision to amend the Constitution, but that amendment should not change the basic structure of the Constitution. But what are the aspects that are included in basic structure that we do not know? According to the cases, the Supreme Court rules that, okay, this is the basic structure and you cannot change it. So, following during the period of all these years, there are certain topics and certain aspects that are included in the basic structure that cannot be changed in future also. So, this is how the list goes on according to the cases. So, under Keshavananda Bharati's case, this case is very important when we are studying Lakshmikant polity, because in many of the topics, this case will be seen as an example, and its judgment results in coming up with new acts, new laws also. So in the perspective of Lakshmikant's polity, Keshavananda Bharati's case is very important. Next, salient features of the constitution. So what is the first one? That is, it is the lengthiest written constitution. So constitutions can be classified into written and also unwritten. So what is the basic difference? First, we'll see what is a written constitution. It is like example, American constitution, and also the unwritten means British constitution. But what is the basic difference between written and unwritten? So in written constitution, we'll have a exclusive book, like how we have the Constitution of India for our country. So it is an exclusively written as the constitution. But under unwritten, like British constitution, there won't be any book, but it will be a collection of laws and acts that are made by the Parliament of Britain. So in that context, it is known as unwritten, whereas written, we have an exclusive book. So that is the basic difference. The Constitution of India is the lengthiest of all the written constitutions of the world. So it's like the superlative in the lengthiest category, in length category. Very comprehensive, elaborate, and detailed document. Originally, 1949, the Constitution contained a preamble, as we studied, 395 articles, which are divided into 22 parts, and 8 schedules. But presently, this is sixth revised version which I am using right now. So presently in 2019, it had a preamble, 470 articles, which are divided into 25 parts and 12 schedules. This is the current composition. There can be a little one or more less if we see to the current date. And one part, that is part 7, which has been repealed. So the part 7 under the Indian Constitution has been repealed and added about 95 articles. 4 parts and 4 schedules. Okay, these are all the additions that are made to the constitution. No other constitution in the world has many articles and schedules. So it is also like something superlative in regard of number of articles and schedules. How many schedules we have right now? We have 22 schedules. I am sorry. We have 12 schedules. And parts also we have 25 parts. Four factors have contributed to the elephantine size of our constitution. Elephantine size means which is in big size. They are geographical factors. Obviously, for a country that has this much of length and breadth, should having a constitution of that size is self-explanatory. And also historical factors. Single constitution for both center and the state. So uh, for state we don't have separate constitution for each state, and we don't have distinctive constitution for center, so there is a single constitution for both center and states, and domination of legal luminaries in the constituent assembly. Okay, so domination of lawyers in the constituent assembly. The constitution contains not only the fundamental principles of governance but also detailed administrative provisions. So it's like uh, it does not only tell about the principle under which the government should be taken care of, but also it gives details about how the process should be done. So it is like a detailed or comprehensive constitution. Further, those matters which in another other modern democratic countries have been left to the ordinary legislation or established political convention have also been included in the constitutional document itself in India. So basically, everything is included in the constitution only. So that's why it is the lengthiest of all the written constitutions. Whereas the second feature is drawn from various sources. So every aspect that we are going to study in the constitution has been almost has been drawn from other constituent countries also. We'll see. And also some of the previous acts like Government Act of India 1935, not only from the constitutions of other countries, but also some of the previous acts that are passed in British under colonial rule. Dr. B.R. Ambedkar proudly acclaimed, proudly saying that the Constitution of India has been framed after ransacking. Ransacking means like something like stealing all the known constitutions of the world. So, who said this? Dr. B.R. Ambedkar said that the Constitution of India has been framed after ransacking all the known constitutions of the world. The structural part of the Constitution is to a large extent derived from Constitution of India Act 1935. So basically the structural part was derived from Government of India 1935, whereas philosophical means under philosophy we'll get DPSP. Okay, we have fundamental rights, DPSP, they derive inspiration from American and Irish constitutions. Later in the video we'll study which thing was derived from which constitution also. Let's not focus right here. So I am skipping this part. The most profound influence and material source of the constitution is Government of India Act. And what are all the things that have been taken from that? Federal scheme, judiciary, governors, emergency powers, public service commissions, administrative details are drawn from this act. More than half of the provisions of the Constitution are identical to or bear a close resemblance to the Act of 1935. So the influence of Government of India Act 1935 is more in the Constitution. So I do not really know if there isn't, as the Jawaharlal Nehru ji said, there shouldn't be any external influence, but I don't get the ambiguity. So let's focus on the studies part now. Blend of rigidity and flexibility. Constitutions are also classified into rigid and flexible. A rigid constitution is one that requires a special procedure for its amendment. So currently, American Constitution is the most rigid constitution because since it's uh, starting in 18th century till now, there have been not more than 10. I don't think not even 10, maybe seven are the amendments that have been made to the American Constitution. So American Constitution is one of the most rigid constitutions where making an amendment is a very tough process, or it is very complex. So that's how the process will be made to a rigid constitution. Whereas a flexible constitution is the other hand that can be amended in the same manner as the ordinary laws. So what flexible is British Constitution, whereas the Constitution of India is neither rigid nor flexible, but a synthesis of both. Let's see how. Article 368 provides for two types of amendments. So the for amending Constitution, we'll get the provision is given under Article 368. It is divided into two categories. That is, some provisions can be amended by Parliament itself, whereas for certain things that they need ratification of states also. So at least 50% of the states should give their nod to the provision, and so then only the amendment can be done. So this is how it is being divided. At the same time, some provisions of the constitution can be amended by a simple majority also. So we have certain things like altering the boundaries of states. So like this, for that, ordinary process can also be used to amend the constitution. So these are the three. One is for ordinary legislative process, for certain provisions where we need special majority, that is two-thirds of members of each house present and voting, and also majority of total membership, that is special majority. And also where along with special majority, we should have at least half of the ratification of at least half of the total states. So this is how the Indian constitution is made both rigid and flexible. Next, federal system with unitary bias. Let's see how. The Constitution of India establishes a federal system of government. It contains all the usual features of federation. So federation means having two governments, one at the central level, one at the state level, and also division of powers, written constitution, supremacy of constitution, rigidity of the constitution, independent judiciary, bicameralism. So independent of judiciary, like High Court has its own jurisdiction, Supreme Court has its own jurisdiction, district courts have their own jurisdiction, so like that. And Indian Constitution. So one thing we need to be more careful here is these options can be given as these things can be given as options and can be asked which one of the following is a feature of federation. So going through this is important. Whereas division of powers, written constitution, supremacy of constitution, rigidity of constitution, independent judiciary, and bicameralism. So these are the features of federation. Now we'll see features of uh, unitary system, that is non-federal, that is strong center. So there are some aspects where central hold is more than the state's hold. And then we have single constitution. So there is a separate constitution for state and center, and single citizenship. So you don't need a different document to show as you move to different states. So throughout the country, you'll have single citizenship. And also flexibility. So whereas rigidity come under uh, federation, flexibility comes under unitary. And integrated. So there is a single line of judiciary, that is from district courts, high courts, Supreme Court. So everything is integrated, although there is independence among each level, but there is that is integrated. And also appointment of state governor by the center. So who appoints governor of the state? President. So who is the governor? He is appointed by the center, so center has the control over that. And also all India services. And next, emergency provision. So these are all included under features of unitary system. Moreover, the term federation has nowhere been used in the constitution. So the term federation hasn't been used in the constitution. Article 1, on the other hand, describes India as a union of state, which implies that two things. One, India federation is not the result of an agreement by the states. So what happens in USA? The 50 states of America, they have come together and made an agreement that they will be under there will be a group, like it is an agreement between among the states to be the United States of USA. But in the context of India, it isn't an agreement. The whole country has been divided uh, politically to facilitate the administrative process. So it's like they haven't come up together to be the Union of India or Republic of India. It isn't a result of agreement. So this is the basic difference. For United States, it is an agreement among the states, whereas in Indian Constitution, it is unitary in spirit, federal in form. So what is that? Indian Constitution, federal in form, like administratively, it is federal, unitary in spirit, okay, and quasi-federal by, it is given by K.C. Weir. So quasi-federal means in some cases it is federal, in some cases it is not federal. And in India, no state has the right to secede from the federation. So tomorrow, a state of Indian territory will come, okay, I don't want to be with India, I'll remain independent, or I'll join with another country. So it has no right to say that, so because it is not an agreement among the states. Here we'll see what line given by each person. So quasi federal given by Casey Weir. Next, bargaining federalism by Maurice Jones. Next, cooperative federalism by Granville Austin. And federation with a centralizing tendency by Ivor Jennings. So these are the basic statements given by different people on the feature that is federal system with unitary basis. Next, parliamentary form of government. The Constitution of India has opted for British parliamentary system of government rather than American presidential system of government. So in America, we know the president of the USA is has more control, and in British we have PM, that is Prime Minister. In British England we have PM, whereas in USA we have President, and we have taken parliamentary form of government. The parliamentary system is based on the principle of cooperation and coordination between the legislature and executive, whereas in presidential system it is based on, so what happens in parliamentary system, there is overlapping of the functions of legislative and executive, whereas in presidential form of government these are exclusive of each other. So there is separation between powers, there is separation between executive and legislation, whereas there is overlapping between legislative and executive organs under parliamentary system. So this is the basic difference. The parliamentary system is also known as the Westminster model of government, responsible government, and also cabinet government. The Constitution establishes the parliamentary system not only at the center but also in states. So both at the center and states level, we have parliamentary system. The features of parliamentary government of India. Now we'll see the features of India, that is presence of nominal and real executive. Who is the nominal head? That is president. President is the nominal head, whereas real executive is prime minister. So whatever the work the PM does, he will do it in the name of the president. So that's why president is called the nominal head, and also PM is called the real head. What happens if the country delegation and or if the country's ministers go to another country? So we have recently seen that we have made FTA, free trade agreement, with Oman and also with New Zealand. These all deals or agreements will be named in the name of president only. Okay, so this is the difference between nominal head and real head. Although it is in the name of president, the real work is being done by the prime minister. And also majority party rule. So whichever party gets majority, that will be in ruling. So at the center, we need 222. That is the majority mark. That is the mark for which the party will be in the ruling. So like that. And also collective responsibility of the executive to legislature. So collective responsibility of executive. Who is the executive? The PM's cabinet, the ministers, they are the executive. And who are they responsible to? They are responsible to legislature. So at the center level, they are responsible to the parliament, and in the state level, they are responsible to the state legislative committee assembly. And membership of ministers in the legislature. So these ministers who are part of cabinet, they will be MP in the parliament also. It's the same thing. So this is where the overlapping happens. So these ministers, they are doing the executive part also, and also they are making laws. So this is the overlapping which we have discussed in parliamentary system. Whereas in America, the people who make the laws are different from people who execute the work. So that is the separation between execution and legislation. Next, leadership of the prime minister or the chief minister. So we have already discussed this, where they are the real executives. And then dissolution of the lower house. So what happens? This Lok Sabha, it will be dissoluted whenever the PM resigns, or whenever there is a completion of tenure. So this won't be the case in the presidential system. Okay. Even though the Indian parliamentary system is largely based on British pattern, there are some fundamental differences between the two. We'll see what. Indian parliament is not a sovereign body like the British parliament. Means the Indian state has an elected head, whereas British state has hereditary head. So monarchy. British is still continuing its monarchy, where King Charles III is current head of British state, whereas the head, who is the head of Indian state, that is they are elected, whether the PM, who is the executive head, whereas the president, who is also he is also elected, and she is the nominal head. So India, it is a republic, whereas British, it is a monarchy. In a parliamentary system, whether in India or Britain, the role of prime minister has become so significant and crucial that political scientists like to call it a prime minister government. So in parliamentary system, the role of PM is very important. So sometimes it is also called as prime ministerial government. And next, synthesis of parliamentary sovereignty and judicial supremacy. So in Indian constitution, there is a mixing of all this parliamentary sovereignty and judicial supremacy. The doctrine of sovereignty of parliament is associated with British parliament, while the principle of judicial supremacy with that of American Supreme Court. So sovereignty, that is related to British parliament, and the judicial supremacy related to Supreme Court of America. Indian parliamentary system differs from British system. The scope of judicial review power of Supreme Court in India is narrower than that of what exists in US. So the jurisdiction or the power of Supreme Court that is in India has less as we compare it to the Supreme Court of the USA. This is because the American Constitution provides for due process of law against the procedure established by the law. So we'll discuss in detail when we are studying fundamental rights. For now, we'll remember that America follows due process of law, whereas India process procedure established by law. Therefore, the framers of Indian Constitution has preferred a proper synthesis between British principle of parliamentary sovereignty and American principle of judicial supremacy. The Supreme Court, on the other hand, can declare the parliamentary laws as unconstitutional through its power of judicial review. The Parliament, on the other hand, can amend the major portion of Constitution through its constituent power. So, we have studied that it cannot alter the basic structure. Okay, the laws cannot alter the basic structure. So, the Supreme Court has that power to say something as unconstitutional and make it void or nullify it. Whereas, to counter that, the Parliament can make the required changes to the Constitution so that it can pass the law again. So we'll see some examples in the future topics also, where there is this counter attack on each other, where a Supreme Court makes something unconstitutional and the Parliament comes up with another law to change the portion of Constitution. Okay, so this is how the power plays between Constitution, Parliament and Supreme Court. Next, integrated and independent judiciary. The Indian Constitution established a judicial system that is integrated as well as independent. So, integrated is under unitary form, whereas independent is under federal form. So, the Constitution, the judicial system in India has both components. We'll see how. The Supreme Court stands at the top of integrated judicial system. As we know, under Supreme Court, we have high courts, and then under that we have subordinate courts, district courts, and other lower courts. So Supreme Court is the apex body of Indian judiciary. This single system of court enforces both central laws as well as the state laws. Okay, this single system of court that starts from Supreme Court till at the lower level to lower courts, they enforces both central and state laws, which is not in USA, where federal laws are enforced by federal judiciary and state laws are enforced by state judiciary. So we have a different judiciary for different laws. If it is regarding to a particular state, the state judiciary will take care of it. If it is for all the states of United America, the federal judiciary will take care. Whereas in India, any court can take up any law. The Supreme Court is a federal court and the highest court of appeal. So if the judgment given by High Court is not appeased, which is not if the person is not satisfied with it, he can go to Supreme Court and appeal for the case again. So the Supreme Court is the guarantor of fundamental rights of the citizens. and the guardian of the constitution. So these are all the features of Supreme Court. Hence, the constitution has made various provisions to ensure its independence. So if the body is having these many powers, like to guard the constitution, so it is mandatory or it is essential to make it independent from parliament so that it independence can be used to guard the constitution. Like how is it, how the independence has been ensured? Like security of tenure of the judges, fixed serving conditions for all the judges, all the expenses of Supreme Court charged on Consolidated Fund of India, prohibition on discussion on the conduct of judges in the legislature, ban on practice after retirement, power to punish for its contempt vested in the Supreme Court, separation of judiciary from executive. So these are all the things that have been taken care of to ensure the independence of judiciary. So here it has given a basic overview, but when we deal with the topic of Supreme Court, we'll go in details about each provision. And then we have fundamental rights, where we have six, that is right to equality. Under that, we have Articles 14 to 18, right to freedom, 19 to 22, right against exploitation, Articles 23 to 24, right to freedom of religion, 25 to 28, cultural and educational rights, 29 and 30, and right to constitutional remedies. So if you think that any of these articles is being infringed or being violated, we also have right to constitutional remedies where the violation of that right or article can be taken care of. The fundamental rights are meant for promoting the idea of political democracy. They operate as limitations on the tyranny of executive and arbitrary laws of the legislature. They are justiciable in nature, means you have justiciable and non-justiciable. It means if we think the right is being violated, we can go to the court. Okay, that is means it is justiciable. If it is non-justiciable, means you cannot go to the court saying that these are being violated. So fundamental rights are non-justiciable in nature. The aggrieved person can directly go to the Supreme Court, who can issue the writs. These are the writs under right to constitutional remedies, that is habeas corpus, mandamus, prohibition, certiorari, quo warranto. So these are the 5 writs that can be used for restoration of the rights. However, fundamental rights are not absolute and subject to reasonable restriction. So just because they have been included in the constitution, they are not absolute. Whereas that means certain reasonable restrictions can be implemented on the rights to ensure the peace. Okay, so these are not absolute. Although they are justiciable, these are not absolute. They can be curtailed or repealed by the parliament through a constitutional amendment. So although these are justiciable, but they are not absolute, and they can be repealed or cancelled by the parliament through a constitutional amendment. They can also be suspended during the operation of national emergency. So during national emergency, all these rights that have been included under fundamental these articles, they can be suspended except 2, that is 20 and 21. Except these 2, they all can be suspended. Whereas there is another article called Article 19, which can be whenever the national emergency is declared, it will be automatically suspended. That Article 19 will be automatically suspended, whereas 20 and 21 cannot be suspended even during the national emergency. So these are some exceptions. And then we have directive principles of state policy, which are under Part 4. These are divided into socialistic, Gandhian, and liberal intellectual. So we'll see in details when we get to the topic. These principles are meant for promoting the ideal of social and economic democracy. Okay, they seek to establish welfare state in India. However, unlike fundamental rights, these are not non-justiciable. So what I told, if it non-justiciable means you cannot go to the court for the restoration of them. Whereas in the view of fundamental rights, they are justiciable. That is, they are not enforceable by courts for their violation. Yet the Constitution itself declares that these principles are fundamental in the governance of the country, and it shall be the duty of the state to apply these principles in making laws. So what the constitution states, it is the duty of the state to apply these principles in making laws. So we do not have, so for suppose, if I say there is one DP, that is, if you see Article 44, it says that, I'm sorry, Article 44 asks for bringing a uniform civil code. So the states can take this principle as an inspiration and they can come up with a uniform civil code. So this is how the DPSP can can make a significance in making laws. However, they impose a moral obligation on the state authorities for application. But the real force behind them is political, that is public opinion. In the Minerva Mills case, which is in 1980, the Supreme Court held that Indian Constitution is founded on the bedrock of balance between fundamental rights and directive principles. So Minerva Mills case, which is in 1980, Supreme Court, what does it say? What did it say? Like Constitution is founded on the bedrock of balance between rights and principles. Next, we have duties, fundamental duties. These weren't in the original constitution. Later, by the 42nd Constitution Amendment Act of 1976, these were added. Okay, the original constitution didn't provide. They were added during. They were added by 42nd Constitution Amendment of 1976 and on the recommendation of Swaran Singh Committee. Okay, so this Swaran Singh Committee has recommended some duties. Out of them, some of them were taken and added by 42nd CA 1976. Later, 86th Constitutional Amendment Act of 2002 added one more fundamental duty. Okay, so in total we have 11 fundamental duties. 10 were added by 42nd Act and the last one was added by 86th Act 2002. The Part 4A of the Constitution, which consists of only one article. So 51A, under this 51A, we have the 11 duties. These are all that is given. We'll go through in detail later. These fundamental rights serve as a reminder to citizens that while enjoying their rights, they also have to be quite conscious of their duties. They owe to their country, their society, and their fellow citizens. However, like the directive principle, these are also non-justiciable. Okay, these fundamental duties also non-justiciable. So, one day you cannot go that this duty has been violated and you cannot go to the court. So, fundamental rights are justiciable, whereas DPSP and fundamental duties are non-justiciable. Next, we have a secular state. The Constitution of India stands for a secular state. However, hence, it does not uphold any particular religion as the official religion of the Indian state. So for the Indian government or for the country of India, there is no official religion. But why? The official provisions of the Constitution reveal the secular character. So these are the provisions that reveal the secular state of the Constitution, Indian state. How? The term secular was added by 42nd Constitutional Amendment Act 1976. Okay, so in the preamble, this secular word was added. Before, in the original constitution, it was not there. The preamble secures to all citizens of India liberty of belief. So they can believe whatever the values they believe in. So some things, some a religion, a person of particular community, he may believe in certain values, or and it may differ from a person in different community. So the preamble secures to all citizens liberty of belief, faith, and also worship. Next, the state shall not deny to any person equality before the law or equal protection of the laws. The state shall not discriminate against any citizen on the ground of religion. So this is one of the factors upon which the state cannot discriminate any citizen. And also equality of opportunity for all citizens in matters of public employment. All persons are equally entitled to freedom of conscience and the right to freely profess, practice, and propagate any religion. So they have freedom to propagate the religion also, any religion. Every religious denomination or any of its section shall have the right to manage its religious affairs. Okay, so any religious denomination has the right to manage its religious affairs. No person shall be compelled to pay any tax for the promotion of a particular religion. So, what no in order to promote the religion, he doesn't need to pay the tax. No religious instructions shall be provided in any educational institution maintained by the state. So, if you see in the government schools, there won't be any restrictions related to that are uh, implemented because of the religion. Any section of the citizen shall have the right to conserve its distinctive language and script or culture. So, any community, so we have several scripts, several languages, several cultures that are that India is home to. So, every citizen is, and he also has the right to preserve them and conserve them. All minorities have the right to establish and administer educational institutions of their choice. So, minorities in the constitution we have two types of minorities, that is linguistic minorities and religious minorities. So this article 30, it guarantees right to establish and administer educational institutions for their choice to all the minorities, but the constitution recognizes only two minorities, that is linguistic minorities and religious minorities. Linguistic minorities are determined by the state on state basis. Okay, so if in a particular state, if you see, suppose if we say one language is prevalent, the people of other who speak other languages can be claimed called as linguistic minority. But when it comes to religious minority, it is based on nation basis. So they'll take up the population of whole country to determine religious minority, whereas it is state-wise in linguistic minority. Next, the last one, the state shall endeavor to secure for all the citizens a uniform civil code. So, what is a uniform civil code? For civil matters like marriage, inheritance, uh, for marriage, inheritance, and uh, their disputes, there should be a uniform civil code that is applicable to all the religions. So, this is how the secularism is being taken care by the constitution. The Western part of concept of secularism connotes a complete separation between the region and the state. This negative concept of secularism is inapplicable in the Indian situation where the society is multi-religious. Hence, the Indian constitution embodies the positive concept of secularism, giving equal respect to all religions or protecting all religions equally. Moreover, the constitution has also abolished the old system of communal representation, that is, reservation of seats in the legislature on the basis of religion. So, in 1909 Act, there has been given separate electorate for Muslims. This has been abolished under the constitution. However, it provides for temporary reservation for scheduled castes, tribes to ensure their adequate representation. So, their upliftment is being taken care of under the constitution, but there is no separate representation based on the religion. So, these are all the features that are covered in this video. In the later video, we'll go through the next set of features and we'll end the chapter. Thank you. Jai Hind.